Now, I'm going to tell something about auditors. Today, I'm going to say something about auditors, their appointment, and their qualifications, and how important role of auditor in the business world. A company carries on its business with capital furnished by persons who buy shares. The owners of the capital are passive, and the real control of the affairs of the company is in the hands of the executive, composed of the directors and officers. The Companies Act provides for the compulsory appointment of auditors to examine the affairs of the company and to report them to shareholders. That examination by an independent agency such as an auditor is practically the only way to safeguard the shareholders, which have against the enterprise being carried on in an unbusiness-like way, or their money being misapplied or misappropriated without their knowledge anything about it. Qualifications of auditor can be discussed under section 226. A person shall not be qualified for appointment as an auditor of a company unless he is a chartered accountant within the meaning of the Chartered Accountant Act 1949, where of all the parties practicing in India are qualified for appointment as a company auditor may be appointed by its firm's name to be auditor of a company, in which case any partner so practicing may act in the name of the firm. It may also be noted that Chartered Accountant Act 1949, only a chartered accountant holding a certificate of practice can be engaged in the public practice of accountancy. A holder of certificate granted by any erstwhile Part B state and state of Jammu Kashmir entitling him to act as an auditor is also entitled to be appointed as an auditor of companies registered anywhere in India. Central government is empowered under section 226 to make rules for the grant, renewal, suspension or cancellation of such certificates. An auditor must be a practicing chartered accountant, a holder of a certificate in erstwhile Part B states entitling him to act as an auditor of companies, and the main object is that properly technically qualified person should be auditor of a company so that he may discharge his duties essentially and efficiently. Disqualifications of an auditor are: a body corporate is disqualified, an officer of a company disqualified, an employee of a company disqualified, a person who is a partner and is in employment as an officer of the company, a person who is indebted to the company for an amount exceeding 1,000 rupees, a person who has given any guarantee or security in connection with the indebtedness of third person to the company for amount exceeding 1,000 rupees. A person shall also be not disqualified for appointment as an auditor of a company if that company is a subsidiary of the subsidiary company, or a company is its holding company, or a company is of that company's holding company. So chartered accountant is subject to disabilities prescribed under Section 8 of the Chartered Accountant Act 1949. Automatic vacation of the office. If an auditor after his appointment suffers from any of the disqualification, he shall be deemed to have vacated his office as an auditor from the date he has become disqualified. After appointment as an auditor of a banking company, if auditor takes loan from the same and bank exceeding rupees of 1,000, he becomes disqualified and has to vacate office as an auditor of such banking company. The object of such restrictions to make the position of auditor as little dependent as possible on the company whose affairs they audit. Position of auditor as an agent. As an agent of shareholders, appointed to carry out certain duties as laid down by the Act. The articles or agreement for the purpose of the audit. However, constructive notice of facts coming to the knowledge of an auditor cannot be imputed to the shareholders. In the absence of any special contract, an auditor is not an agent of company. If he signs a statutory report or a balance sheet specifying its correctness, that does not constitute an acknowledgement of a debt by an agent of the company. So far as third parties are concerned, the auditor does not owe any duty of care unless he has a contractual relationship with the third party or he knows that his skill or judgment will be relied on by the third party. Secondly, he acts as an officer for certain purposes. He is liable for wrongful acts and for defaults just as any director or employee of the company for the purpose of these certain sections from 478, 545, 539, 621, 625 and 633. However, he is entitled to the relief of any officer may claim. As an employee, the relationship between auditor and a company is that of a professional man and client, rather than that of a master and a servant. Now, as a detective, an auditor is not bound to be detective to approach his work for suspicion. He is a watchdog, but not a bloodhound. That means his duty is verification, not detection. He is justified in believing that servants of the company in whom confidence is placed by the company and assume that they are honest. Lastly, as an advisor, auditor is not an advisor of the company. It is no part of his duty to give advice, either to directors or to shareholders, as to what they ought to do. How an auditor can be appointed? First, auditors of the company shall be appointed by the board of directors within 1 month of the incorporation of a company. So, auditors so appointed shall hold office until the conclusion of the first annual general meeting of the company. So, company may at general meeting remove auditors appointed by the board. In their place, any other person as an auditor can be appointed, can be nominated for the appointment of the company. If the board fails to appoint such auditor, the company may, in general meeting, appoint first auditors. They are not required to inform the registrar of companies whether they have accepted the appointment or not. Board of directors have been given the power to appoint first auditor to ensure that the company does not remain without any auditor till the first annual general meeting. Now, appointment of subsequent auditors. At annual general meeting. The authority of appointment of auditor of a company rests primarily with the shareholders. Subsequent auditors, they must be appointed at each annual general meeting of the company, and such auditors who are appointed shall hold office from the conclusion of that meeting until the conclusion of next annual general meeting. Every company within 7 days of the appointment of auditor at its annual general meeting give intimation thereof to the auditor so appointed. Every auditor so appointed shall inform the registrar within the period of 30 days of the receipt of the information of his appointment. Now, period of office. The auditor is appointed for a particular period from the conclusion of one annual general meeting until the conclusion of the next annual general meeting. Auditor will continue in the office until next annual general meeting is held and concluded. In next annual general meeting happens for any reason to get adjourned, the auditor will continue to hold the office until the conclusion of the adjourned meeting. Sometimes appointment is made by a special resolution. Normally such resolutions they can be passed by a simple majority. Public financial institution or a government company or a central government or any state government or any financial or any other institution established by Provincial State Act, which a state government holds not less than 51% of the subscribed share capital. A nationalized bank or an insurance company carrying on general insurance business, the appointment or reappointment of each annual general meeting of the auditor or auditors shall be made by a special resolution. This provision that in the case of a company in which government or public financial institution or nationalized bank have a stake of 25% or more, the auditor is appointed only with the concurrence of the government or of certain organizations. Suppose there is a failure to appoint an auditor. Where any company referred to above omits or fails to pass or its annual general meeting a special resolution to appoint or reappoint an auditor, it shall be deemed that no auditor has been appointed. In such case, company within 7 days give a notice of that fact to the central government, and the central government will appoint a person to fulfill the vacancy. Reappointment of a retiring auditor. In an annual general meeting, a retiring auditor, by whatever the authority appointed, shall be reappointed, except in the following cases. He is not qualified for reappointment. He has given a notice of company in writing that his unwillingness of reappointment. Where the notice has been given an intended resolution to appoint some person or person in the place of retiring auditor by any reason of death or incapacity or any other disqualification that may be of a person or persons, the resolution cannot be proceeded with. So the expression shall be reappointed postulates some action on the part of the company resulting that reappointment of a retiring auditor. He cannot be deemed to be reappointed or automatically reappointed on the annual general meeting. So passing of resolution for the purpose of annual general meeting seems essential for the reappointment of retiring auditor who is still qualified and willing to act. Casual vacancy, it can be filled up by the board. While any such vacancy continues, the remaining auditor or auditors, if any, may act. But where such vacancy is caused by resignation of auditor, it shall be filled by the company in a general meeting. Such an auditor shall hold office until the conclusion of the next annual general meeting. It may be noted that two or more auditors of a company, there is a casual vacancy in the office for one or more auditors, and the remaining auditors may act. Thank you.